Okay, my name is Erica Nahara. I'm arguing on the affirmative to overturn DOMA. Subpoint A, same-sex marriages do not get federal benefits. Liz Skinner, philanthropist who covers college funding. Gay spouses struggle to claim benefits. May 27, 2012, November 25, 2012. The Federal Defense of Marriage Act, passed in 1996, specifically states that marriages must be between one man and one woman. As a result, same-sex couples can't take advantage of the income tax benefits of a joint federal income tax filing or other important federal benefits. These include passing Social Security benefits onto a surviving spouse, avoiding estate taxes when inherited as spouse assets, giving gift tax-free to spouses, receiving federal disaster aid benefits, and others. Subpoint B, homosexual marriages are unequal. Evan Wolfson, homosexual, should be allowed to marry. Audrina Ojeda, San Diego, Greenhaven Press, opposing viewpoints. All together now. September 11, 2001, November 26, 2012. Marriage is many things in our society. It is an important choice that belongs to couples in love. In fact, many people consider their choice of partner the most important choice they will ever make. Civil marriage is also a legal gateway to a vast array of protections, responsibilities, and benefits, most of which cannot be replicated in any other way. These include access to health care and medical decisions for your partner and your children, parenting and immigration rights, inheritance, taxation, Social Security, and other government benefits, rules for ending a relationship while protecting both parties, and the simple ability to pool resource or buy, transfer property without adverse tax treatment. After passing the federal anti-marriage law marketed as Defense of Marriage Act, which defined marriage as a legal union between one man and one woman in 1996, the government cataloged more than 1,049 ways in which married people are according special status under law. Add in the state-level protections and the intangible and tangible privileges marriage brings in private life, and that makes more than 1,049 ways in which lesbians and gay couples are ripped off. Subpoint C, inequality in America is unconstitutional. Jeffrey Stone, Dean of Law at Chicago University Law School. The Defense of Marriage Act is unconstitutional. HuffingtonPost.com, November 26, 2012. In the following viewpoint, he discusses that 2010 ruling by federal judge that Defense of Marriage Act DOMA violates the constitutional right of married same-sex couples to equal protection under law and reverses the federal government's long history of allowing states to set their own marriage laws. Stone concurs with the ruling of the court that the creation of DOMA was motivated by specific animosity towards gays and lesbians, usually based in religious beliefs, and is therefore unconstitutional. Subpoint C2. The United States was founded on equality. Jack Green, professor in humanities at Johns Hopkins University History Department, Charlottesville University Press, Virginia, 1992. Perhaps no single phrase from the Revolutionary era has had such continuing importance in the American public life as the dictum, all men are created equal, in the Declaration of Independence. For each generation, it has served an imposing reminder of what Americans might achieve as a standard against which they could measure how far they had to go. Just what it meant to its author, Thomas Jefferson, and his contemporaries has been a prenatal subject for debate within American historical community. What precisely could a phrase have meant in society so riddled by inequalities as early America? For contemporaries, the meaning of the word equal was in itself quite equivocal. It meant, according to Dr. Samuel Johnson, being upon the same terms, not inferior or superior. Contention 2, subpoint A. Full faith and credit clause will be recognized. Joe Wolverton, Marriage and Law Understood Properly, Full faith and credit clause, March 7, 2005, November 27, 2012. In the press, on talk radio, and on television, self-styled conservatives and liberals are warning Americans that forced recognition of homosexual marriage is inevitable because of the requirements of the full faith credit clause of the Constitution. That is to say, a homosexual couple who is legally married in one state, Massachusetts, for example, would have that union legally validated in all other 49 states because the Constitution requires such among the states. Subpoint B, restoring the full faith and credit clause will cause states to validate marriages from other states. Julia Edwards, staff reporter for the National Journal. Activists make case for DOMA repeal. July 2011, December 1st, 2012. Repealing DOMA would not force states to recognize or churches to perform marriages for same-sex couples. It would create a federal mandate to respect the law of states of Connecticut or other states who choose to legalize the marriages. Should a couple move to a state where gay marriage is not legal, a DOMA repeal would allow them to keep their benefits. Subpoint C, validating marriages will grant federal benefits to gay marriages. Mark Tasser, professor of law at Capital University. What if DOMA were repealed? Law Journal, November 29, 2012. Suppose then that DOMA is repealed. Without this provision, the presumption that the domestic relations are established by state rather than federal law would control. For example, same-sex couples who were not married in Massachusetts would be entitled to federal benefits, just as different-sex couples who marry in Massachusetts are entitled to those benefits. Subpoint D, federal benefits will fulfill constitutional rights. Bound to American lawyer and civil rights advocate. Civil marriage is the locus of civil rights struggles. December 1st, 2012. Every civil rights... I'm now open for cross-examination.
Erica, in your contention 1, can you read to me the citation for subpoint C?
The whole thing?
Yeah.
Okay. In the following viewpoint, he discusses a 2010 ruling by a federal judge that the Defense of Marriage Act, DOMA, violates the constitutional right of married same-sex couples to equal protection under the law and revises the federal government's long history of allowing states to set their own marriage laws. DOMA concurs with the ruling of the court that the creation of DOMA was motivated by specific animus towards gays and lesbians, usually based in religious beliefs, and is therefore unconstitutional.
Okay, can you read the citation for me, please?
Yes, it is Jeffrey R. Stone, Dean of Law at Chicago University Law School.
Would you say that the evidence is kind of hearsay in that, because it doesn't actually account for Stone's actual personal beliefs? It just says what Stone says in his article that he wrote.
Yes, I would agree.
Okay, so would you agree that that would be invalid, or would you say that it would be valid evidence?
I mean, I still believe that it's valid evidence, because whether it's his opinion or what he wrote, it's still what he thinks.
Okay. Can I have your cards, please, or your evidence?
My evidence cards?
Yes, or whatever, it doesn't matter.
The one you see?
Yeah. Thank you.